Good afternoon. My name is Lukasz Korporowicz. I'm an assistant professor in the Department of Roman Law at the University of Lodz, and I have this great joy that I can deliver this talk to you today. First of all, I'd like to express my thanks to Paul Lizzie for his kind invitation to participate in this event. It's a pity, unfortunately, that we were unable to see each other in person in Edinburgh, as it was planned first. But thankfully to the technology which we have now, this event was able to be organized in a little bit unique way, but maybe because of what is happening currently in the world, this way of communicating, scholarly communicating, became less and less unique. My papers today is titled 18th Century Civilians and the Art of Legal Word, English Law and the Foreign Laws in the Teaching Materials of the 18th Century English Civilians. It is generally accepted that the non-Roman law or the non-jus commune teaching started in England when William Blackstone offered his private lectures in 1753 in Oxford. Shortly later, these lectures were redesigned to be public ones. This was a consequence of establishing the very first chair in common law in Oxford, the Vinerian chair, in 1758. Common law curriculum, however, was still long distance in the future, and Oxford and Cambridge offered their first common law degrees not before the mid-19th century. In fact, it can be added today that the first academic degree in common law was granted by the William and Mary College, which is represented by my fellow speaker today, Professor Tom McSweeney, already in 1793. As to the non-civilian teachings, however, there is no doubt that at least one major attempt to teach common law before Blackstone occurred. That was Thomas Wood's lectures delivered at the beginning of the 18th century. Their content was published later in 1720 by the author under the title An Institute of the Laws of England. The main aim of my paper today is to focus on the content of the Roman law lectures delivered by the English civilians in the 18th century, and to try to figure it out how much attention they devoted to the non-essential non-Roman law matters. This aim is based on two fundamental concepts. First, the relation between the Roman law and the canon law or ecclesiastical law. Theoretically, the teaching of canon law was disembarked from Oxford and Cambridge in the 1540s as the aftermath of the English Reformation. But allowing the ecclesiastical courts in England to function without major change, along with most ecclesiastical administrative structures, made that prohibition an obsolete one. Canon law was still part of the legal curricula at both universities, that is Oxford and Cambridge. Its teaching could not be as transparent as before the Reformation, but the Regius Professors of Civil Law, the holders of the two chairs established by Henry VIII to teach Roman law, were including canon law into their teachings regularly. Secondly, general task of the Regius Professors was to teach Roman civil law, of course. And of course, candidates to the degrees of the bachelor and doctor should be well trained in the law of the ancient Romans. But the studies at Oxford and Cambridge were suggesting that the lack of knowledge of the laws of their own country would be to some extent disgraceful. In Oxford, Regius Professors were ordered to implement during their lectures some information regarding their laws, regarding the laws of England. Later, this regulation was echoed during the doctoral disputationes. One of the questions asked during them should deal with the local laws, the so-called jura municipale. Besides, the statute explained that the doctor of law should know the law of his own country, as well as he should be able to compare English law with the foreign laws. Now, how the teaching of Roman civil law in 18th century England looked like? What was the environment of that teaching in the 18th century? We have to come back to 17th century. The 17th century, with its political upheaval, seriously influenced English culture and education. The consequence of these problems, at least in the sphere of academia, were visible still through the 18th century, and in the opinion of some of the historians of education, these burdens were thrown away not before the 19th century. Among these educational problems, the following one can be enumerated. First, lack of students. Secondly, transforming academic posts into the sinecures. Then, avoiding lecturing by the lecturers. This picture, however, cannot be expanded into all scholarly disciplines. In case of legal education, that is the teaching of Roman civil law, at least the teaching was more or less continuously running throughout the entire 18th century. The scholarly work of the Roman law professors, in turn, is a different story, which I will not be talking about today. Since the English Reformation, the legal education at Cambridge, at Oxford, was entrusted into the capable hands of the so-called Regius Professors of Civil Law. The freedom of selecting the teaching material bestowed to them by Elizabeth I meant that they could decide what and how they want to teach. This freedom was, of course, designed as freedom of teaching Roman law only. But for the professors, it meant that they can teach different other issues, not necessarily current Roman civil law. And for example, Robert Jenner, who was teaching in the mid-18th century in Oxford, was known to teach mainly about the law of nations instead of proper Roman law. Most of the civil law students were hoping to work as lawyers and judges at the ecclesiastical as well as in the admiralty courts. Those who were most ambitious were planning to link their career with the Society of Doctors' Commons and to practice inter alia at the Arches, the court of the Archbishop of Canterbury. Many others, however, were planning to get simpler provincial job in one of the local ecclesiastical courts. Some of them were devoting themselves to stay at the universities where they could be elected fellows in one of the colleges, and partially they could participate in the academic work as well as they could be the judges in the university courts. All these judicial bodies, ecclesiastical, admiralty, and university one, were forced to use the Roman canonical procedure to deal with their cases. Even if that procedure was not the same as the one created by legists and canonists in the late Middle Ages, still, Roman canonical pattern was well visible. In addition, as far as the canonical rules were not against the laws of England, and more precisely against the rules governing the Anglican community, the medieval canon law was still in use in England. An example of such situation was the use of the canonical rules forbidding the clandestine marriages. These rules were originally introduced during the Fourth Lateran Council of 1215 and survived in England till the Reformation and to the reforms of Lord Hardwicke in 1770s. At the same time, these rules were changed in the Catholic Church already during the Council of Trent in the mid-16th century, but of course that had no impact on English law. For these reasons, the ecclesiastical law was an important part of the teaching undertaken by the civilians, and the lecturers were eagerly adding the elements of canon law knowledge into their lectures. Because of the complexity of this matter, however, I will not focus on it today. This subject was discussed by me elsewhere, and in case if someone is interested in it, you may find a link to my article on this subject in my presentation. As it was mentioned before, the statutory regulations known in Oxford and Cambridge encouraged both lecturers and students of law to study English law. These encouragements were predominantly concerning those who were planning to obtain the doctoral degree. Their pursuit for legal knowledge should not be finished with obtaining the degree in civil law, but they were exhorted to look carefully at English law. For these reasons, Regius professors were known to submit certain local elements and comparisons into their lectures. When we talk about teaching the law in Oxford and Cambridge, it should be emphasized also who was responsible for these teachings. Naturally, the primary group of lecturers were the Regius Professors. Throughout the 18th century, professors were regularly appointed to both chairs in Oxford and Cambridge. The longest vacancy lasted around a year and a half when Henry Brooke, professor in Oxford, died in 1752. One of the candidates to succeed him was William Blackstone. Although his candidature was well evaluated, the Duke of Norfolk, then the Prime Minister of Great Britain, was not in favour of Blackstone. For this political reason, his candidature was postponed and finally rejected. New professor Robert Jenner was appointed in 1754. Besides this delay, however, the appointments of the remaining professors take place rather smoothly. It is true, however, that this was not the only instance of governmental or sometimes royal influencing the appointing decisions. Besides the Regius Professors, there were plenty of deputy professors appointed throughout the century. Not all appointments were fully formal, and for this reason we do not have full list of the deputy professors. Many future Regius Professors were deputizing their predecessors first. This was not, however, a solemn rule. In some cases, the right of teaching Roman law on behalf of the chairholder was granted informally. Thomas Beaver, for example, obtained such permission from Robert Jenner. It is interesting, however, that Beaver was continuing his lectures after the death of Jenner when the new professor, Robert Van Sittert, was appointed in 1767. It seems that he did not apply for the new permission from Van Sittert. This seems to be quite strange, since Jenner's permission was granted because of his poor health. Finally, the third group of lecturers are the civilians who were the fellows of different Oxbridge colleges. Some of them were undertaking these duties as a part of their formal obligation towards the students, like in the case of Robert Eden, who taught in the University College, Oxford. In some other instances, the decision was made by the civilians themselves. They were deciding to deliver private lectures to the students. And this is the case of Thomas Wood of New College. As to the lecture notes and materials that survive until modern days, there are unfortunately many gaps. Sometimes it is possible to locate quite well a description of the teaching habits of certain civilian, certain professor, but nothing more. In the following part of my paper today, I would like to focus on 3 lectures that deserve closer analysis. They are Wood's civilian lectures from the early 18th century, Thomas Beaver's Oxford lectures delivered by him in place of the Regius Professor of Civil Law, and finally published versions of Samuel Halifax's lectures delivered by him in the late 1760s and 1770s in Cambridge. Now, let's start with Thomas Wood's lectures. Thomas Wood was an Oxonian, member of a new college, one of the traditional civilian colleges in Oxford. He was trained still in the late 17th century. In 1687, he obtained the degree of Bachelor of Civil Law, and then in 1703, he obtained the doctoral degree. A year later, in 1704, his textbook on civil law was published. It was titled New Institute of the Imperial or Civil Law. His work was quite successful. It had 4 editions. The last one was published in 1730, already after Wood's death. As it was mentioned before, Wood was quite probably the first proper teacher of English common law in Oxford as well. In 1720, he published his second textbook written in an institutional manner and titled An Institute of the Laws of England. It is worth mentioning also that Wood was a member of the Gray's Inn, but he was called to the bar only as an honorary barrister at law. As to Wood's teaching, there are not many detailed information. Robert Robinson, who analyzed Wood's textbooks in an article written back in the early 1990s, observed that both textbooks have clear pedagogical background. This is well seen in the introduction to Wood's New Institute, Civilian pointed out there that his work aims to encourage young scholars to spend some few hours in the study of the civil law. But just one or two sentences later, he stated that I have added notes and therein observed the chief differences of the other nations from it, and what conformity or disagreement there is in the law divine, what alterations have been made in the canon law. The pattern and the idea of the textbook was borrowed by Wood from John Cowell's Institutiones Juris Anglicani, early 17th century institutional work on English law. These borrowings were recently emphasized by Julia Rudolph in her book Common Law and Enlightenment in England, 1689-1750. It can be observed also that Wood did not only base his lecture on Cowell's treatise, but he was attempting to enter the scholarly discussion with Cowell, once the Regius Professor of Civil Law at Cambridge. Wood differentiated his aim from Cowell's when he wrote, Dr. Cowell shows some differences and agreements in the civil law by an institute of the laws of England in Justinian's method. I have shown some disagreements in the laws of England by way of notes added to a new system of the civil law. And later he added, my endeavor has been to adapt my observations on the laws of England to the present establishment. As it was already mentioned, there is limited information regarding Wood's teaching habits. For this reason, it is not possible to recreate Wood's method of presenting the non-Roman law elements of his lectures to the audience. But in the printed version of the lectures, all non-Roman law elements are placed in between the main corpus of the text, in the square brackets. It is important to add that all Wood's non-Roman law opinions were equipped with the adequate quotation of the scholarly literature. In this aspect, there is a clear difference between the Roman law and non-Roman law material. Whenever Wood was discussing Roman civil law, he equipped his text with the reference to Roman law sources. While he was referring to non-Roman law material, he always referred to scholarly literature, and in the case of English law, also to the statutes. English law and foreign laws are used by Wood on many occasions. He is referring to them as a consequence of discussing specific problems of Roman civil law. For example, after discussing the age of entering into the valid marriage according to Roman law and the need of confirming that act by the father of the family, Wood inserted into his textbook a substantial note regarding the same matter according to English law and its relation to the canon law, named by Wood as pontifical, as well as the French law. This kind of elaborate comments did not always characterize Wood's style. After presenting the civilian rules that no one disposes his state partially with the use of the testament and partially according to the rules of intestate succession, Wood commented swiftly, by the English law it is otherwise, as in France and Holland. In addition, he illustrated the validity of his assertion by referring to Swinburne's treatise on ecclesiastical law and Vinus's commentary to the Institutes of Justinian. Another group of Wood's notes can be described as terminological. Several times, he explained the terms characteristic to civilian tradition by exhibiting their common law counterparts. For example, the term coheirs is explained by him as coparceners, while the two persons that were given something by legacy are described by Wood as the joint tenants. Among the English legal literature used by Wood, several words have to be enumerated. It seems that John Cowell's institutional work that laid the fundaments for Wood's textbook was not used by him to create the notes inserted into the text. The most widespread and comprehensive work to which Wood is referring are Kirk's Institutes. In the opinion of Julia Rudolph, Koch's work was equally important for Wood's treatment of English law as the Cowell's work. Another English law book used frequently by Wood is Doctor and Student by Christopher Saint-Germain. This seems to be an obvious choice, as far as his textbook is not a legal treatise, but a textbook focused on students' needs. Doctor and Student was fulfilling such an aim for the learners of English law until the publication of Blackstone's commentaries later in the 1760s. Other works are quoted only occasionally. Among them are Henry Swinburne's work on testaments and wills, John Fortescue's De Laudibus Legum Angliae, Matthew Hale's Historia Placitorum Coronae, Simon Digee's work on fifths, and single references to Bracton. Henry Finch's Nomotechnia and Thomas Wenworth's The Office and Duty of the Executors are also mentioned. As to foreign laws, it has to be explained that Wood used the reference to the legal systems of other countries in a different way. He discussed them in the introductory part of his textbook, and later in the main part of it, he was just pointing out the similarities and differences between Roman law, English law, and foreign laws. In general, he was not attempting to make some wider discussions about the foreign laws. In his introduction, Wood described shortly the legal systems of several countries, mostly as a part of the history of the reception of Roman law in European history. He began rather unorthodoxly with the reference to the laws of the Turks and showed information that they make use only of the Justinian's Greek code. Then he comments on the relation between ancient law with the customs, canon law, and the legal concepts developed in Italy. He treated separately Venice, Milan, Naples and Sicily, and Lombardy. Then he moved to the northern countries, and he dealt with Germany and Holland, where the Roman civil law is esteemed to be the municipal law. He noticed, however, that many parts of the law of the Romans are obsolete and altered. He described Friesland as the refuge place for the civilian tradition, but in the remaining part of the Germany, Jus Saxonicum, Lubesense, or Kulmense is preferred. Denmark and Sweden are only mentioned by Wood. He stated that they were not observing any or only minimal influence of civilian tradition. A relatively long paragraph was devoted by Wood to the French legal culture. He noticed the difference between the provinces of customary law at the southern part where the Roman law can be detected in the municipal laws. He also discussed canon law, ordinances, and the criminal law. Later, he moved to the Iberian Peninsula. In his opinion, Roman law and canon law were corrected there, both in Spain and in Portugal, by the royal law and customs. Finally, he emphasized vaguely the relation between the civilian tradition and the Scottish statutes, Acts of Serjeant, Regia Majestatem, and customs. After that, he described shortly the structure of English law. The mentioned analysis was based by Wood on the pattern of Arthur Dach's De Usu et Autoritate Juris Civilis. Also, he referred to Simon Groeneweggen's Legibus Abrogates, Jean Thomas Les Lois Civiles dans leur ordre naturel, and George Mackenzie's The Institutions of the Law of Scotland. In the main part of the textbook, as it was mentioned before, Wood referred to particular countries and their legal systems. These references, however, were not immensely developed. The most common parallels were designed between England and France and Holland. Also, German example was used quite often. Among other countries, Wood referred to the Italy in general, as well as to particular countries, that is the Kingdom of Naples and Sicily, and separately to Milan. Then he referred several times to Spain, Denmark, Switzerland, Sweden, but also to Poland. Scotland is mentioned also several times, 3 or 4. In general, it can be pointed out that Wood's attempt to discuss English law was much more learned than in the case of foreign laws. In the first case, he was trying to explain English law and to share some thoughts about it with his students. That is true that sometimes Wood was giving a short description of particular concepts, but in general, they were material. In the case of foreign laws, they are almost always echoed by simple enumeration. Wood is usually proclaiming that a certain concept is used or is not used in particular country. More elaborate descriptions are occasional, and if they happen, they are dealing with the French legal tradition. For this reason, if it is plausible to say that in case of English law, Wood is attempting to perform some kind of comparative analysis, in the case of foreign laws references, nothing more can be said that only these are simple analogies. Now let's move to Thomas Beaver's lectures. The second civilian whose lectures survived until modern days is Thomas Beaver. His story of teaching Roman law in Oxford is different than the one observed in the case of Wood. Beaver matriculated in 1744 in Oriel College. At first, he was studying the arts. In that discipline, he obtained a bachelor degree. Later, he moved to All Souls College and started to study law. He obtained a bachelor and doctoral degree in civil law, respectively, in 1753 and in 1758. Shortly after obtaining the doctoral degree, he became a member of the Doctors' Commons and he became an advocate. In the following years, he was appointed a judge of Cinque Ports as well as the chancellor of 2 dioceses. Nevertheless, Beaver was still holding his fellowship in All Souls College. In 1762, Beaver started to teach Roman law in Oxford. The character of his lectures were subject of some uncertainty among the scholars. It was clear that Beaver was not appointed the Regius Professor of Civil Law. His teaching was coincident with the professorship of Robert Jenner and later Robert Vansittart. It looked then like Beaver would deputize these professors. He was never described, however, as the deputy professor. John Barton suggested that Beaver could hold the private lectures like the one held half a century earlier by Wood. This fact can be currently confirmed to some extent. The manuscript of Beaver's lectures, currently at the University of Edinburgh archives, bears the following information. This course was first opened on May 10, 1762, before a private audience of young gentlemen of the university. Still, it is confirmed elsewhere in the printed version of Beaver's introductory lecture published in 1766 that he was lecturing with the permission of the Vice-Chancellor and with the approbation of the King's Professor of Civil Law, whose ill state of health has long deprived the public of the fruits of his abilities. This information suggests that Beaver was deputizing Jenner with his permission, but without a formal appointment to the post of deputy professor. It is not clear why he was destitute of receiving this title. As to the lecture materials, at least 3 of their versions survived until modern days. Partial lecture notes survived in Trinity Hall, Cambridge, as manuscript 41. They contain only 4 lectures on persons, family statutes including husband-wife relation, origin and return of property, and finally, occupancy. There are also 2 complete sets of lectures, the first one held by All Souls College, manuscript 109, and the Edinburgh set of 5 volumes of the lectures. In addition, there are at least 2 versions of Beaver's course program, the first one currently in the Newberry Archives in Chicago, which can be dated to 1764, and the second one is an addition to the Edinburgh's lecture, and this can be dated for 1772-1773 version. As it was mentioned earlier, the early version of Beevor's introductory lecture was published in 1766 in Oxford under the title A Discourse on the Study of Jurisprudence and the Civil Law. This version, however, was not repeated by him in the following years. At least the Edinburgh manuscript contains a redesigned introduction. As to the structure of the lectures, it must be emphasized that they were predominantly Roman law focused. They were divided into three parts: an introductory and on private law, on political law, and on public law. Besides, Beevor equipped his lecture with a so-called appendix that contains the description of different European legal systems. This final part is most interesting for this paper. The appendix increased its size gradually. In 1764, it was planned to be discussed during one final lecture of the course. As Beevor explained in the syllabus, the appendix was designed as of the progress of the civil canon and feudal laws in the later ages, and of the reception in the various countries of Europe, wherein is contained, as far as relating to the present subject, a summary review of the several constitutions. In the printed version of his introductory lecture, Beevor added at the end of it a description of his Oxford course. As to the appendix, he explained that it contains historical deduction of the union and progress of the civil canon and feudal laws in later ages, and of the reception in the various parts of the Western world, together with a summary of the present constitutions of European countries, and more particularly the extent and effects of these laws in the kingdoms subject to the British Crown. In 1764, Beevor discussed the legal systems of the following countries: German continent, France, Italy state, Spain and Portugal, Poland, Prussia, Sweden, Denmark, Russia, Turkey, Scotland, Ireland, and England. Nearly a decade later, in the academic year 1772-1773, the general structure of the lecture remained unchanged. The number of lectures, however, held in the academic year increased immensely. The appendix was taught this time during the 3 final lectures. As to its content, only small changes have been made. Beevor added 2 new legal systems to be lectured on about Holland and Switzerland. I have to explain here that Beevor's lectures are currently under research subject that I'm planning to analyze much closer in the following years. For this reason, my findings in this area have to be treated as preliminary. As to England, Beevor analyzed certain concepts regarding its constitution in his published introduction titled A Discourse on the Study of Jurisprudence and the Civil Law. It has to be emphasized that the general idea of that discourse, like in the case of its later version that can be observed in the Edinburgh manuscripts, which bears the title Preliminaries Historical and Moral, are mostly concerned on the theoretical ideas regarding the law as such, its objects and virtues. For Beevor, the law is deeply rooted in religion and morality. He is in favor of the Ulpian's definition of jurisprudence as the divinarum atque humanarum rerum notitia. For this reason, his references to both Roman law as well as English law in the discourse are rather illustrations of certain truths proclaimed by him than the proper analysis of the legal concepts derived from both legal traditions. Among the most interesting proclamations made by Beaver is the one reflecting the early history of the common law. First, he admitted that the early development of the English constitution shall be connected with the fact that the ecclesiastics were almost the only scholars and the only lawyers in the kingdom, and being chiefly foreigners, had contracted a contempt for the English constitution, whose defects were then but too visible. Later on, Beaver proclaimed, "What use our ancestors have made to the civil law will readily appear to anyone that will take the trouble to compare the several works which compose the voluminous body with some of the most ancient English lawyers as Glenville, Bracton, and others, who have adhered very closely to the rules and method of Justinian, have transcribed his laws in their own language, and sometimes almost entire titles, as familiarly as if they were the ordinary laws of England." Besides these short references to the relation between Roman and English law, Beaver was discussing the English constitution with the characteristic zeal of the Englishmen of the second half of the 18th century. He is speaking of its perfection, the term so eagerly used a couple of decades later by Edmund Burke and his followers during the pamphlet wars. The same is seen in the further part of the discourse, where Beaver is dealing with the problem of foreign laws, constitutions, and the experience of foreign nations. He declared that the English constitution stands firmer upon the basis of its own policy than of the Roman or of any other in the universe. But when we take any foreign laws in pieces and examine the materials with which they are constructed, we cannot say this pillar is ill-contrived or ill-proportioned only because it will not answer the scale of our building. It may have a peculiar grace and elegance in the place for which it was designed, though the whole fabric altogether is inferior in beauty to our own. The English law literature was not used by Beaver with too much elaboration. He records sometimes the authority of English statutes. In the discourse, he referred 3 times to Matthew Hale's History of the Common Law. He also made some mentioning of ecclesiastical lawyers, Thomas Orton, Henry Swinburne, and John Godolphin. For the more elaborate comparison between English and Roman law, Beaver referred to the notes added by George Harris to his translation of Justinian's Institutes, published for the first time in 1756. It is seen that Beaver was focusing predominantly on the proper lecture of Roman law. He was not willing to explain too much of the similarities and differences of both legal systems. Foreign laws are important for him as far as they should be known by a learned person, but he is not troubling himself too much with the extensive comparisons. In this sense, his attitude towards the Roman law teaching and the knowledge of the laws of foreign nations is quite different from what was represented and what we have seen looking at Thomas Wood's textbook. Now, the final lecture that I'd like to discuss today are the lectures published by Samuel Halifax. The lectures that require some closer look are the one delivered by this civilian. He was the only one out of the 3 Roman law teachers who are mentioned by me in this paper who was appointed to the Regius Professorship. Also, unlike the previous 2 civilians, Halifax was not an Oxonian, but a Cambridge man. He was first admitted to Jesus College, where he obtained bachelor and master's degree in art. Then he moved to Trinity Hall, where he was elected a fellow, and in 1764 he gained a doctoral degree in laws. At the same time, he was appointed a deputy professor of civil law, and he was deputizing William Reddington, then the Regius Professor. It was commonly anticipated that Halifax will become the next Regius Professor. For this reason, His decision in 1768 to apply for the professorship of Arabic was widely commented and criticized. In addition, his only competitor was his own cousin and friend, John Jebb. Nevertheless, Halifax was appointed to the chair of Arabic studies, and he held it for 2 years. At the same time, he was still holding his deputy professorship in civil law. But when in 1770 Ridlington finally died, Halifax swiftly transferred himself for the civilian professorship. He stayed at Cambridge until 1781, when he became a bishop of Gloucester. Halifax was teaching Roman civil law both during his deputy professorship as well as after the 1770 appointment. His teaching skills, however, were purely evaluated by his students. It is noted by one of his former students that during the lectures, Halifax was technically reading his lecture notes, but he was doing this so fast that no one could write down and comprehend what he was saying. There are 2 versions of Halifax's lectures, both are published. At first, when he was still a deputy professor, he prepared the heads of a course of lectures on the Roman civil law compared with the laws of England, published in 1769. His lecture was based on the institutional system, but its content does not cover the law of obligations, or more precisely contracts and delicts, and the actiones. The place where this version of Halifax's lecture is stopped suggests that Halifax was delivering the lecture in first 2 terms of the academic year, and the final part of the lectures was delivered in the Easter term by Ridlington. This assumption is based on the fact that the personas and most of the rest parts of the Justinian's Institutes, more or less 2/3 of the entire ancient textbook, was covered by Halifax's lecture. Later, already as a Regius professor, Halifax prepared the larger version of his textbook, titled An Analysis of the Roman Civil Law Compared with the Laws of England. This cannot be treated as a new work. In fact, Halifax only added the remaining parts of the institutional scheme to his previous textbook. This step, however, was inconsistent. While the original part was rather straight, written in the form of enumeration of the particular problems connected with the described legal concepts, the new part was much more descriptive. Despite this unfortunate style, Halifax's textbook enjoyed considerable popularity in the following decades. Besides the first edition published in 1774, the following 2 editions were published still during his professorship in 1775 and in 1779. His successor, Joseph Jowett, prepared another edition in 1795, and the following Regius professor, James William Geldart, prepared an enlarged version of the textbook in 1836. The university's calendar, published in 1854 during the professorship of Henry Maine, contained information that the lectures generally follow the order of subject observed in Halifax's analysis. This was written more or less 80 years after the first edition of the textbook was printed. Regarding the subject of this paper, it must be emphasized that the comparative character of Roman and English law was declared by Halifax already in the titles of both of his textbooks. Also, he avoided foreign comparisons, which were relatively common in the case of wood and beaver. The only non-English comparison made by Halifax are single references to German and French legal concepts. They are made, however, marginally and without further consequences for the content of the lecture. As to the English elements, Halifax made an interesting and amusing declaration in the preface to the analysis. He said, "Besides a regular analysis of the civil law, which continues the main design of the ensuing work, there is a second which is subsidiary to it, and may perhaps by some be thought a more useful as well as interesting part than even the principal subject, namely the comparison which is made all along between the Roman laws and those of England. Halifax pointed out that he was following into the steps of Cowell, once the Regius Professor at Cambridge. As to the English law, Halifax mentioned Blackstone's commentaries as a source of his knowledge. The great assistance I have received from the commentaries on the laws of England. He also enumerated Harris's notes on Roman English law relation and the comparisons inserted by Harris into his translations of Justinian's Institutes. As to the content of the lecture, English law is indeed referred by Halifax on many occasions, both from the structural as well as dogmatic point of view. The very first chapter of the book, the same in the head and an analysis, bears the title of the Roman civil and canon laws and their authority in England. Unlike the previous lecturers, Halifax was discussing English law not next to Roman law, but he was weaving the English problems into the civilian fabric of the textbook. Sometimes he restrained himself and was only declaring that certain concept is similar in English law or it is not known in England at all. It is quite easy to find, however, larger passages where he discusses the English concept rather thoroughly. A good example of either use of English law are parts of Book 1, Chapter 3, of persons in general and of freedom of slaves. After detailed comments to relevant passages of Justinian's Institutes, Book 1, passages 3 to 8, after analyzing the legal statute of the slaves and their offspring in Roman law, Halifax commented, "The law of England differed in this respect from the civil law." Later, when he finished his civilian deliberations regarding the slaves, he started to discuss slavery in England. He declared that in the past, English law knew the so-called villenage, which was a state little better than slavery among the Romans. He also added that copyhold tenures now subsisting in England are descended from the ancient villenage. The same passage, however, is differently concluded in the head and in an analysis. The earlier version of the lecture contains the following statement. In what sense a slave or a Negro by landing in England became free? The baptism of heathen slaves makes no alteration in their civil condition. This is a passage taken from the head. In an analysis, final statement was changed into this one. The revival of domestic slavery in America affords no proof that the introduction of a new slavery in England is now lawful. Both statements are clearly in agreement with then more and more acceptable opinion among the English lawyers that when the enslaved person stands on British soil, then he or she becomes momentarily a free person. Blackstone did not refer, Halifax did not refer to Blackstone's opinion, which was not originally placed in the first edition of the commentaries, that the enslavement is restored or can be restored when the former slave leaves Britain and returns to the colonies. Generally speaking, Halifax's references to English law are numerous, but they are not incredibly detailed. This is not surprising when the entire textbook will be evaluated. It can be assumed, at least in the case of the early version of the textbook, that Halifax was using it as a very expanded syllabus of the lecture. At least in case of the Roman law comments, they are usually rather short explanations that demand from the student to look at the same time at the original text of Justinian's Institutes. Reading Halifax's textbook without the Institutes would be extremely hard and would not supply the student with sufficient knowledge. English law references, then, are only an addition to the main subject of the textbook. Regarding the literature used by Halifax, it is possible to observe his steady expansion in that area. The heads are lacking any references. In the first edition, 1774, of an analysis, Halifax added some footnotes, Finally, the 1775 edition of an analysis contains a short summary of the most important basic literature that covers the subject of the following chapter. The study of these summaries gives an interesting result. As it was mentioned before, Halifax proclaimed that his knowledge of English law was based fundamentally on the readings of Blackstone's commentaries. This is confirmed by the number of references to Blackstone's work in the bibliographical summaries of the chapters added in the second edition of an analysis. Blackstone's work is mentioned in most of the chapters, altogether 45 times. Besides, Halifax referred once to Blackstone's other work, today rather neglected and forgotten, the Great Charter and the Charter of the Forest, that contained Blackstone's edition of the Magna Carta. Halifax relied also heavily on Wood's and Institute of the Laws of England. Very often, both Blackstone's and Wood's work are referred by Halifax side by side. Although Halifax referred to Cowell's work in his preface, in the main part of the textbook, his work is quoted only once. On the margin of the delictual matters, Halifax referred instead several times to the English criminal law. While doing this, he mentioned William Eden's Principles of Penal Law. Other works were used by Halifax only exceptionally. Among them are Duck's De Usu et Autoritate, Richard Hurt's On the Constitution of the English Government, Daines Barrington's Observations on the More Ancient Statutes, and Francis Thornton Sullivan's Lectures on the Feudal and English Law. On several occasions, Halifax mentioned court decisions. Lord Hardwicke's decision in Evelyn against Evelyn, Lord Mansfield's decision in Wyndham Chadwind, Halifax called Lord Mansfield then a great lawyer, and Hargrave's arguments on the case of Somerset. It is noticeable that many of these comparisons were made by Halifax regarding property law, including the rules of inheritance. In comparison to Wood's and Beaver's lectures mentioned earlier, Halifax focused much more on English ecclesiastical law. He discussed many Roman legal concepts related to family, marriage, guardianship, etc., with the references to ecclesiastical law. His knowledge in this aspect was based on the works of Burn, Gray, and Orton. Now, as to the conclusions. Discussed lectures are only an example of the larger problem, and it is hard to say that the outcomes of this analysis are comprehensive. Presented analysis should be treated as a preliminary one, and the issue of teaching the law in Oxford and Cambridge still deserves closer attention. Beaver's lectures, just like the one attributed to Francis Dickens, which were not discussed today, need much closer archival study. Wood and Halifax, although their lectures were published, did not gain much interest among the legal historians. This is, in fact, a larger problem of avoiding the 18th century English legal history studies in general. There are, of course, some brilliant exceptions from that behavior, but in general, 18th century is still not an immensely popular subject of scholarly research among the legal historians. What can be said, however, is that the 18th century civilians were not self-limiting themselves to the study of Roman law and eventually ecclesiastical law. First, some civilians were technically interested in studying English law, and among them, two were mentioned today, Thomas Wood and William Blackstone. Both were trained civilians, and both have written treatises on English law. Besides, statutory regulations regarding the need to study English law by at least Doctor of Civil Law or Doctor of Laws in the case of Cambridge were not meaningless provisions. It seems that the lecturers, Regius professors as well as their informal teachers, were trying to equip their students with at least fundamental knowledge regarding their local law. This seems to be an interesting and overlooked aspect of the history of English legal education. Traditionally, it is believed that the civilians were only teaching Roman civil law, while the English law was solely taught in the Inns of Court, with changing proficiency. It is plausible, however, that Oxford and Cambridge were much more involved than previously thought. There is no doubt that the scale of English law themes discussed by the civilians is hardly extensive, but after all, full presentation of English law subjects was not an aim of the aforementioned civilians. For these reasons, their interest and readiness for discussing these issues are worth noticing. The question of foreign laws, instead, is less systematized. Adding the information about the foreign legal systems was rather an own decision of the lecturer. Even if the Oxford Statutes were admitting that the future civilian shall be able to compare his legal system with the foreign laws. Eventually, each of the discussed lecturers treated this subject differently. Wood was treating the foreign laws just as he was treating English law, as a subject of simple, plain comparison. On the other hand, he was teaching English law separately. We have to remember about this. Beaver did not include the foreign laws as well as English law into the main corpus of his lecture, but he was focusing on them in a separate final part of the lecture. And finally, Halifax did not devote his lecturing time to foreign matters at all. This should not be very surprising. The teaching of Roman law was justified by the tradition and the ecclesiastical needs. The teaching of English law was based on the university statutes and a natural interest in the law governing a society that the civilian belonged to. Now, the justification of foreign laws can be based more on the curiosity and comparative interest of the lecturers. Thank you very much for your attention.